Salute you all. Thanks for listening. Thanks for being on. And today we are going to look at criminal procedure as a course unit. Basically, where you feel that you haven't understood, please feel free to ask any question in the comment section. So basically, today we are under criminal procedure, and today we are going to look at extradition as a topic under criminal procedure. So basically, what you have to bear in mind, or what you have to put in mind, is that extradition is governed by the Extradition Act, Cap 124, which is under the 7th revised edition. So it was changed from Cap 117 to 124. So note that in mind. So basically, what you have to know about extradition, it is aimed at basically surrendering a fugitive criminal from Uganda to a country where he would have committed, or where a country, such a fugitive, would have committed a particular offense. This country is known as the requesting country, then Uganda is known as the surrendering country. So probably note that in mind, or bear that in mind about extradition. And basically extradition is like you're trying to bring back that offender, or the fugitive is known as a fugitive, from that country where he has ran to a country where he has committed a particular offense. That is extradition. And when you read section 1 of the Extradition Act, defines what a fugitive criminal is. Here basically they defined a fugitive criminal as any person accused or convicted of an extradition crime within the jurisdiction of any other country who is or is suspected being in Uganda. So basically note that in mind about extradition. And the key point under extradition, the country cannot extradite a fugitive who is charged of a crime of political nature. When you read section 3A of the Extradition Act and section 23 of the Extradition Act provides that the requirement of that for a fugitive criminal to be surrendered, the offense committed should not be a political in nature. What do they mean by political in nature? It must not be in line that it is in political, either fighting government or opposing the government, among others. So there they cannot extradite you. You get? So basically note that in mind. You cannot be extradited anyhowly once the offense is in political in nature. You all understand what political in nature: fighting the opposition, having a political party, opposing the government, among others. You get? The offenses, when you read section 28 of the Extradition Act, all the offenses that are not every offense that is extradited, but section 28 provides all offenses that can be extradited. So note that section. All offenses of extradition are there. There's no offense that, some offenses cannot be extradited. You get? So there is a good case of Ricastoni of 1891 provides that in order for an offense to be of political character, it is not, actually they say that it must at least be shown that the act is done in furtherance of, or done with the intention of assistance as a sort of an overt act in the course of acting in a political matter, political rising, or a dispute between two parties in the state, as to which is to have the government in its hand. So basically, political nature, that's the question that normally court asks itself. What do they mean by the question, by the offense of political nature or the offense of political character? You get? So in any case that provides that government affairs, politics, parties, among others, it becomes the offense of political nature. And basically, section 7 of the Extradition Act provides that any person, you understand, that has committed an offense that is extradited can be extradited. You get? So note that in mind, or bear that in mind. And when you go further about the procedure, how someone can be extradited, they start from But you start by requisition. When you read section 22 and section 8, a requisition is made by the minister, by the state that wants to extradite someone to the minister of that particular state. You understand? So a minister is the one to issue, to write to the magistrate, requesting him to do what? To arrest, you understand, the fugitive. You understand? And when you see that, when you read section 9, section 1 of the Extradition Act provides the issuing of a warrant of arrest against the criminal. So the magistrate acts on the orders of the what? Of the minister. You understand? And issues the warrant of arrest against the criminal. You get? But however, in section 10, actually this section, go back and read them verbatively. But I'm trying to give a brief explanation. Then when we read section 10, provides for the hearing of cases and evidence. So here the magistrate calls the what? Calls the criminal to induce evidence to make sure that the person is not being convicted of an offense of political what? Nature. So the criminal has a right to defend himself that the offense is of a political character. So I cannot be what? Extradited. If the magistrate gets to know that the offense is of a political character, then the criminal is discharged from what? Custody. You get? But however, if he's liable, then the person will be put for custody for 15 days until he's extradited or is surrendered over to the requesting state. Understand? So he'll be put in custody and waits for the minister's what? Report. You understand? Or the minister's what? Say on how he can be what? Extradited. But if somebody is put for 15 days, but if the person is put in court for more than 15 days, like for 3 months, when you read section 13 provides that then the High Court will be forced to discharge him or her from custody. So bear that in what? In mind. You get? So basically that's what I can say about what? Extradition. So basically note that in mind. So thank you for listening. I just wish you the best.